I'm Drew Stevenson, and this is a lecture for my Statutory Interpretation and Regulation class, or Leg-Reg, about statutes that incorporate another statute by reference. In modern times, we call this the reference canon. I'm doing two separate videos about this canon. This one is going to explain the rules, and then I'm going to have a separate second video that goes through a couple of quick case examples to illustrate it. Now, the bottom line is a lot of our statutes in state codes and federal codes refer to other sections of statute or incorporate other state law just by a general reference. So it may say something like as defined in section 123 of this statute, or it may say as defined according to the laws of this state. And that expression matters. The traditional and majority rule is that if it's a specific reference, then it freezes in time the wording of the other statute that it refers to. So even if that other statute is amended subsequently, the statute that refers to it, it's as if it copied and pasted the original language into the statute, which means you have to find the version of the statute at the time of enactment of the primary statute. If it's a general reference, then it does contemplate all subsequent amendments, and it's whatever the law is now at the time of the case. So to illustrate this, I decided to go with the most recent articulation of the rule by the United States Supreme Court. In Jam versus International Finance Corporation, the Supreme Court had to apply a federal statute called the International Organizations Immunities Act of 1945. The parties were obviously advocating for different readings of the statute. Justice Roberts wrote the majority opinion, and at one point he says, the reading from one party is confirmed by the reference canon of statutory interpretation, and he expresses it this way. When a statute refers to a general subject, the statute adopts the law on that subject as it exists whenever a question under the statute arises. Now, and the statute in this particular case was a general reference to federal law. In contrast, he says, when a statute refers to another statute by specific title, the reference statute is adopted as it existed when the referring statute was enacted without any subsequent amendments. Justice Roberts goes on in this 2019 opinion and says, federal courts have often relied on the reference canon to harmonize a statute with an external body of law that the statute refers to generally. And so when it's a general reference, then you use the current version of the statute. If it's a specific reference, he says you use the version of it at the time of enactment. So other commentators and legal sources and secondary sources have expressed this somewhat differently, and some of them may add clarity for you. So here's a quote from Corpus Juris Secundum, section 356. A statute which refers to and adopts the provisions of a prior statute is not repealed or affected by the subsequent repeal or amendment of the prior statute. In such a case, the incorporated provisions considered as part of the second statute continue in force and are unaffected by the repeal. This rule, however, yields to a discernible legislative intent to the contrary, and that may be the case here in Texas, where we have a code provision that seems to say to do the opposite of the traditional rule, or a legislature could put language right in the statute that has the incorporating reference and says, as incorporated by section 123, as amended after this date. And so that would signal to a reviewing court that what they really intended to do was have the court look at whatever the law was at the time. Justice Roberts, in that opinion, that JAM opinion from 2019, cited the Sutherland statutory construction treatise, although his clerks somehow got the numbering of the sections wrong in the opinion, it seems like. But he quoted that as a source, and Sutherland's 51.7 and 8 is about these referencing statutes. I find Sutherland's, it's nice because it's authoritative, but the language is very clunky and it kind of rambles on and on unnecessarily. But I did pull out a couple of quotes that I really like the way they express things. And one is in 51 subsection 7, it says a general incorporation includes subsequent amendments, and a specific incorporation does not. That's a nice, very concise way of stating the traditional rule. General incorporation includes subsequent amendments, specific incorporation does not. In the next section of Sutherland's, it goes on and says, a repeal of a referred statute has no effect on the reference statute unless the reference statute is repealed by implication with the referred statute. And so what this is saying is, if you have a statutory section that refers to, it says, let's say, as defined in section 123 of the state's code, and section 123 is later repealed altogether, it doesn't even exist anymore, that doesn't matter, because if we're applying a statute that refers to 123, it refers to it at the time it existed when the statute was enacted, unless when we repeal it in such a way that we say this hereby repeals all statutes that also depend on this or refer to it, or that the statute that incorporates the other one by reference essentially collapses, right, because of the nature of what's done by the repeal. So you could have a repeal by implication, but as you know, when we've talked about repeals by implications, they are disfavored by the courts. Here's a quick example from a very commonly invoked and enforced statute nowadays, 18 U.S.C. 922G. This is the firearm prohibitors, prohibition factors. The most common one is G1, which is the felon in possession statute. But I want you to notice in G3 and 5, the incorporations of other statutes, which could present troubling issues in coming years. So 18 U.S.C. 922 G3 says it shall be unlawful for any person, 3, who is an unlawful user of or addicted to any controlled substance. And it says right in the statute, as defined in section 102 of the Controlled Substances Act, and then gives a reference to the codified version at 21 U.S.C. 802. So stop right there. I want you to imagine that in the next congressional session, Congress decides to decriminalize marijuana. Well, we may have a problem then, right? Because unless they go back and also fix the firearm statutes that incorporate the Controlled Substances Act by reference specifically, then you could still go to jail under this statute for if you are a user of marijuana and have a firearm, right, are found in possession of a firearm. And again, because it's a specific reference. And so a subsequent repeal of marijuana criminalization would not affect another statute that specifically refers to it by reference. Or if you look at 5, it talks about aliens or immigrants are not allowed to have guns. Basically, an alien who is A, illegally or unlawfully in the United States, or B, except as provided in subsection Y2, that's of this section, statute 922, has been admitted to the United States under a non-immigrant visa, as that term is defined in section 101A26 of the Immigration and Nationality Act. And so these people are prohibited from shipping, transporting, or possessing any firearm or ammunition. And the punishments are quite hefty. So again, this is just an example to illustrate a federal statute that matters a lot and that comes up a lot, incorporating other statutory sections of the federal code by reference. Let's move on. Okay, just a special problem to note that a lot of state laws incorporate provisions of federal law by reference, sometimes specific sections of the federal code and sometimes just referred to as defined by federal law. And sometimes federal laws incorporate state law by reference. And an example of the latter is we have some federal laws about Social Security benefits for survivors. children of people who pass away. And so the survivors benefits laws say that benefits paid to your minor children if you die prematurely depend on state law to determine who is legal offspring. And the US Supreme Court has had to consider cases about in vitro fertilization and sperm banks and people becoming pregnant from someone, a partner, after the partner has died and so forth. And they will incorporate state law refer to it in making their decisions. Okay, a special problem, but I think this actually explains the logic of the traditional rule. Incorporation by reference was very problematic before the era of computerized legal databases that you could search, like Westlaw and Lexis. Legislators who, remember, in the days when it was only books, which was a long time, legislators, if they wanted to amend or repeal a statutory section, really had no practical way to go through every single page of the United States Code and make sure that find every section that incorporated the statute that they wanted to change by reference that referred to it. And to see what other laws had incorporated that specific section was just too difficult, and you would never know for sure that you hadn't missed one. So when you wanted to amend a statute, it was very hard to anticipate how other laws would be affected by the proposed change. By the way, even though now this would only take a few minutes, the electronic checking about this is still rather sloppy because it just hasn't been part of the tradition of lawmaking in our country. But it makes sense then that courts, on the one hand, if they're thinking, like, let's say you have a statute that's passed in 1969, there's no way that the legislature could contemplate all possible future amendments that could happen to a statute that they're incorporating by reference, if they say as defined by this other statute. And similarly, a legislature in 1971 that wants to change the referenced statute has a problem, right? That they can't always know what all of the effects on other sections of the code. And so it kind of makes sense from that standpoint that the courts decided to just freeze the statute that's referred to in time. Okay, I just want to draw your attention to two variations on this that are modern and kind of weird. The first is the Uniform Statute and Rule Construction Act, which is very interesting but hasn't gotten a lot of traction. As far as I know, this has been adopted only by the state of New Mexico. But this is put out by the National Conference of Commissioners on Uniform State Laws that put out other things like the UCC and other uniform laws. And they were hoping that states would adopt it. And so here's how they wanted to tweak the reference canon. First, they have it broken into 4 parts, and I'm going to split onto 2 slides. A statute or rule that incorporated by reference another statute of the state incorporates a later enactment or amendment of the other statute. In other words, they're kind of turning the traditional rule on its head and saying we're always just going to go with whatever the current version is of the incorporated statute. B, a statute that incorporates by reference a rule, and by that they mean a regulation of the state, does not incorporate a later adoption or amendment of the rule. And so they draw this kind of strange distinction that I don't really understand between statutes and regulations. And so a statute that incorporates a regulation by reference, then we're going to freeze it in time so that if that regulation is amended later, it doesn't matter or change the meaning. But we are going to allow the referenced statute, when statutes cross-reference another statute, that an amendment to one affects the other. Look at C. A rule that incorporates by reference another rule of the state incorporates a later adoption or amendment of the other rule. So regulations that incorporate other regulations, again, it's going to be whatever the current version of the referenced regulation is. And then look at D, a statute or rule that incorporates by reference a statute or rule of another jurisdiction. So, and the most common one is a state statute that incorporates a federal law, does not incorporate later enactments or adoptions of amendments of the other statute or rule. I guess I can see the logic of that in the standpoint that Congress shouldn't have to think about or research every single state law that refers to a specific federal section when they want to amend something or change the language of a statute. But still, this sort of way of breaking it into 4 branches is a little weird, and I am not aware of very many states that have adopted this approach. But look at what we have in Texas. We have a couple of code sections in Texas that use very similar language and say, unless expressly provided otherwise, a reference to any portion of a statute, rule, or regulation applies to all reenactments, revisions, or amendments of the statute, rule, or regulation. In other words, this appears to be a rejection of the traditional rule, and says that you don't have to look up the old version of the statute at the time of enactment. Instead, just when something refers to another statute, look up the current version. Here's another section of this Texas code. Unless expressly provided otherwise, a reference to any portion of a statute or rule applies to all reenactments, revisions, or amendments of the statute or rule. So what this means for I teach in Texas, so most of my students are going to practice law in Texas. And what I would encourage you to do when you're in practice, if you are applying a statute that refers to another one, is watch out, check this Texas code section and see how the courts are applying this nowadays. Are they taking it seriously, or are they ignoring this and applying the rule from the U.S. Supreme Court from 2019, which is more recent than this? Remember, the U.S. Supreme Court's rule would be binding on federal courts, but not on Texas state courts. But you should definitely check. In most jurisdictions, if you're watching this video outside and are going to be working outside of Texas, you're going to follow the traditional rule that we find that the Supreme Court has articulated and is found in Sutherland's treatise and CJS. Okay, that concludes our first video. Please make sure you watch the second video, the follow-up, where I give a couple quick case examples that illustrate how this works and why it matters.